We appreciate your interest that you have in the conveyance of water rights. Looking out over the audience, we see lots of familiar faces, and lots of you we have associated with. But for those of you who are not familiar with us, I am Sue Glenn, and this is my colleague here, my teammate, Dana Dredge, and we are the Title Program Specialists at the Division of Water Rights, and we're also known as the Title Team. So most likely, if you have issues with your title or your ownership, or you need some guidance, everything that you submit to the division regarding ownership comes to us. That's why we ask that you be very nice to us. So we will get started, and what we plan to be covering in our presentation today is, first, the statutes that do govern ownership on water rights in Utah. And that would be under Utah Code 73-1-10. And this code actually addresses how water rights are conveyed. It addresses deeds, the exceptions to those deeds, and the recording of those deeds. And also under this statute, it addresses what is required to update ownership on the records of the Division of Water Rights. Then the other important code that we'll be covering is under Utah Code 73-1-11. And this code is extremely important because it does address a pertinence of a water right to land. In addition to the statutes, we will also be highlighting the administrative rules that support those statutes. Then next, we'll guide you through our mapping standards and what's required when you're going to submit your maps when you're trying to update your ownership by the appurtenance. We will be discussing report of water right conveyances, or as we call them here at the division, ROCs. And this will be including how to properly fill out a ROC, the documents that are needed to be submitted with that ROC, and the submission of the ROC to the division. We will also be covering how to process the ROC once it's been submitted to the division. And last, we will be reviewing the administrative rule when there appears to be a conflict on the ownership of a water right. So it is our goal that when you leave here today, you will hopefully have a better understanding of those statutes and the rules that do support those. And then we particularly hope that we can convey to you the understanding of an appurtenance of a water right in relation to the land. We hope that you will also know our mapping standards and that you will know what's required on your maps when you submit the ROCs. And then hopefully we can take you through the process of how to complete a report of water right conveyance so you will know how to fill one of those out successfully. Now, our stated mission of the Division of Water Rights is to provide order and certainty in the beneficial use of Utah waters. So in an effort to provide that order and certainty on water rights, the division strives to maintain quality record keeping. And quality record keeping includes keeping the ownership current on the records of the state engineer. But however, with respect to ownership of a water right, our records are only as good as what has been submitted to us. So if you as a water user has purchased a parcel of land that has a water right, or you have purchased a water right specifically, it is your responsibility to notify us of that ownership change. And what we have found is that when people have discovered they've got a water right, and they haven't updated their ownership, then usually it's because they wanted to change some aspect of that water right. It's generally because they need to now drill a new well, or they want to change the place of use, or possibly the nature of the use. Just keep in mind that if that does occur, the division will most likely tell you you will need to update your ownership before you can move forward with any administrative action on that water right. So when the title team does receive calls regarding ownership on water rights, it's generally because someone has either bought land that has a water right, or someone is selling land and has discovered they may have a water right. When this occurs, there are typically two questions that are frequently asked when they call Dan and I. And the first one, of course, is, what is a water right? I have no idea. I have this water right. What is it? Well, Chris has covered that in his presentation. But the second question is, how is ownership of a water right transferred? Under our code, section 73-1-10, it states that a water right shall be transferred in substantially the same manner as real estate. So simply stated, to transfer ownership on a water right, a deed is required. Now, your deed can specifically recite the water right in its entirety, or it can convey a portion of that water right. Or a water right that is authorized to be used on a particular parcel of land can also be conveyed by what we call a pertinence. So here we have two examples. Hopefully you can see these. We have two examples of deeds. The one on the left is a land deed. And you will note that this land deed conveys a metes and bounds description only, and no specific water right is mentioned in that deed. If it has been established that this metes and bounds description is the place of use of that water right, then most likely this water right has been conveyed by the appurtenance. Now on the right, you will see a water right deed. This deed does specifically convey the water right. And it, as I mentioned before, it can convey the water right for 100%, or it can convey it for a portion. Now, just remember that water deeds, once they've been executed and recorded, they could possibly separate the ownership of that water right from the ownership of that land. So then there is no longer the unity in ownership between the water and the land. Does everybody understand that? Okay. Okay. So we'll go on now to another way to possibly convey a water right. And this is by an assignment. Now, an assignment cannot convey a perfected water right. And Chris covered perfected water rights in his presentation. An assignment, however, can transfer ownership on an approved application to appropriate water. And this can include approved exchanges that have not yet been perfected, or unapproved applications that have yet been approved by the state engineer. Now, our assignment forms are provided by the state engineer, and they are available on our website. Prior to 2014, assignments were not required to be recorded with the county recorder. And notably, this caused some problems when giving notice to the public of ownership transfers on water rights. So effective as of May 13th, 2014, all assignments are now required to be recorded with the county recorder. And then just recently, included under section 73-3-18, added to the statute and beginning July 1st of this year, a copy of that assignment, when it's recorded, may be forwarded to the county, may be forwarded by the county recorder to the Division of Water Rights. And the division will then treat that submission as a report of water right conveyance to update ownership on a water right. Keep in mind, though, that this only applies to transferring by the assignment 100% of that water right. So now we'll talk about addendums. Sure.
I'm not used to the assignments. When would they be used?
Let Chris, so everyone can hear your question.
So I'm not used to using assignments. In what context would they be used?
An assignment, again, would be used if the water right is an approved application or an unapproved application. It cannot be used to transfer ownership of a perfected water right. And again, as Chris mentioned, if you, a perfected water right under the statute is either a certificate, it's a diligence claim, undergroundwater claim, it can be a water user claim that was filed in a proposed, in a general adjudication and published in a proposed determination. So it's probably suggested that if you are wanting to convey a water right, it's best to go and look at what type of a water right it is before you decide whether you should be using a deed or an assignment.
Okay, so you would use an assignment if you couldn't use a deed?
Depending on the type of water right. And if you're not sure, you can always call into our office and we'll guide you through that. Okay, we'll talk about addendums. So, an addendum is an attachment to a deed. An addendum cannot convey by itself. It is merely an attachment to a deed, and what it does is that it acts as a report of conveyance. So it is a form that was approved by our legislature, and what it does is it identifies the water right that's transferred under that applicable deed, or it states that no water rights are being transferred under that applicable deed. Its purpose is to actually create a dialogue between the buyer and the seller of that property, and whether or not any water rights are included or not included in that sale. That's what the purpose of that addendum is. Now, there are two types of addendums. There's an addendum that can be attached to a land deed, or an addendum that can be attached to a water deed. And the forms, again, are found on our website. Jim will take you through our website and show you where all of our forms are located. This addendums are actually governed under our Code Section 73-1-10 and also as provided in the Real Estate Code 57-3-109. Effective as of July 1st, 2011, an addendum attached to an applicable deed can act as a report of water right conveyance. So in effect, when an addendum is attached to a deed and recorded with the county recorder will then forward to the state engineer a copy of that deed and addendum, and then that will take the place of what is required, the report of water right conveyance, to update records on the state engineers. So the addendum can be forwarded by the county recorder either by mail, by email, or by fax. And if you choose to use a deed and addendum, there are certain requirements. And this is established under Rule 655-3-3 if you want to refer to that copy of the rules that you have. The requirements are, first, you need to include all grantor's signature on that addendum. So all grantors that appear on that deed also have to sign the addendum. Same thing with the grantees. All grantees that appear on that deed need to sign the addendum. And also the grantee's mailing address. Now, this is another main important thing to note if you're going to use a deed and an addendum, is that those need to start with the owner of record as they are listed on our website. I mean, they're good to use, but if they're being submitted to us from the county recorder, the only way ownership is going to be updated, if all of these items have been done, is if that deed and addendum does start with the owner of record. Yes. Yes, let Chris give you the.
So let's say that, on your records, the water shows in party A, and it's transferred 2 or 3 times since then. Now it's party D that's selling. So if we had a deed addendum from D to E, and then later submitted a report of conveyance that documents from A to D, does that deed addendum retroactively kick in and become effective?
No.
Okay.
It will not retroactively kick in. No. Most likely what will happen is if we get the deed with the addendum that comes in first before any report has come in from A to D, that deed and addendum will be sent back because we will tell you, you need to start your chain of title beginning with A. And that is one of the problems that we do incur. That's why I'm just saying, before you decide to, it's always a good thing to have that dialogue, and we encourage that with the buyer and the seller, no doubt. That should be talked about, and the water should be talked about. And that's what the purpose of that addendum is. However, if you're going to use that, please make sure that you have checked to see who the owner is listed on our records. If the owner is not who the buyer and the seller are, then you're going to probably want to just choose to use a report of water right conveyance submission instead. Any more questions on that? Okay. No, I'm a little behind on this. Okay. So now, if the Division of Water Rights cannot update title on that deed and addendum, the state engineer will provide written notice to the grantee that does appear on that addendum, and the reasons why we can't update. So, again, notably, there are 2 reasons, again, why most likely we aren't able to update. 1, you didn't start with the owner of record, and 2, 1 or more of the parties did not sign the addendum, and a lot of times the mailing address has been forgotten to be filled in. And we just want to emphasize that some people tend to think that the addendum is a conveyance document itself. Again, it is not. And also, once that deed and addendum has been recorded, it can only be submitted to us by the county recorder. We do not accept a professional hand delivering a deed and addendum to update ownership, nor do we accept an individual bringing one in to update our records. If they're going to do this, they need to submit it with the proper forms to submit. Any more questions?
Sue?
Yes.
Would you ever use a deed writer along with a rock then? Would you ever need both of those? An addendum.
We do receive rocks where a deed with an addendum is done, yes. And in fact,
Why?
just to mention this is a little bit of the crazy thing with these addendums. If you have read through the instructions on those addendums, it actually says that you're also supposed to submit a rock to us along with the fact that you have recorded that.
That's what I'm getting at.
Okay. No, you do not have to submit a rock in addition to having submitted the deed and addendum with the county recorder. The only time you're going to need to submit the rock again is if you haven't started with the owner of record or it's been sent back to you for some other reason. Then you will have to go through the process of submitting a rock to us. So is that clear?
Thank you.
But you do not have to submit, just because you've recorded it doesn't mean you have to turn around and do a rock too. No. Some people do, just to assure that we have received it. And that's the other thing. Unfortunately, in the statute, they didn't say that the county recorders had a time frame in order to send those to us. So it all depends on when we receive them from the county recorder. We do have a couple of counties that are very lax in sending them to us. We've had one county, when they first came about, we had one county that said they're just going to go in La La Land. So, and we do not follow up on those if they have been recorded. Again, it's your responsibility to make sure that they've come to us. So some professionals have chosen to also submit a report of water right conveyance. That way, we have received it, and there's the assurity that one way or another, ownership will probably get updated.
Thanks.
Okay, so let's now talk about the county recorder. The county recorder is the office of official record for the conveyance of water rights, and true ownership of a water right can only be determined by researching the deeds at that county recorder's office. The deeds are to be recorded in the county where the point of diversion is located and also where the water is used. So if you have water used in one county and the point of diversion is in another, you're going to be required to file that deed in both counties. Now, a recorded deed from the time of its recording shall constitute notice to all parties of its contents. And here's another date. Effective May 13th, 2014, the county recorders were then instructed from that date on to now keep a separate track index of all conveyances relating to water. So when you're doing a title search, you now can also do a title search of the land, and hopefully from 2014 on, they're also keeping one of the water. We just want to make a side note that, the Division of Water Rights does maintain a database of all water rights, including ownership for those water rights. But the division does not monitor the transfers of water rights at the county recorder's office. So again, we're only as good as what has been submitted to us. The responsibility is on the water user to make sure that when there is a transfer of ownership that they update our records. And you're also encouraged to do a full search of the title at the county recorder's office, because that is where the true ownership is shown. Don't just depend on our records for having the true ownership. Most times we don't. And then we also have that disclaimer at the top. We make no claims to the accuracy. Okay, I'll turn the time over to Dana. She's telling me no, but I'm telling her yes.
I've got one of those voices that carries, so I don't know if I need a mic. But, okay, appurtenance. What is the definition of appurtenance? That is always the question, because people are going, what is appurtenance? I mean, maybe a more familiar definition to you guys would be maybe an incidental right, such as a right-of-way attached to a principal property right and passing with it. But the definition of appurtenance with water rights is all water is the property of the public until a right for its diversion and use is established. Okay, at that point, when it's established, the water right becomes appurtenance with its place of use. Okay, so when a water right has been established or perfected, as Chris talked about, or even approved for use of a specific parcel of land, the water right can be considered appurtenant to that piece of land, okay, for land conveyances only. When there's no water right number on the deed, you could convey that by appurtenance. A map will be required depicting the place of use on the water right overlain by the metes and bounds in the deed. Okay, individuals, we all get confused. A lot of people get confused with this, so I'm going to go over some examples appurtenance. You can't. Can you hear me now? Okay. When we say, can you guys all hear me? Okay. When we say water right is appurtenant to its place of use, it is the place of use listed on the perfected or approved document. Okay, so here is a certificate of beneficial use that Chris talked about as a perfected document. Now here, if you look at the certificate, it shows the place of use right here, the 0.25 in the southeast of the northwest, and it shows one family. That is the uses, and the place of use is located in the southeast of the northwest. This place of use is also listed on our maps, on our map viewers, on our map view, and which Jim will show you that later how to obtain that or get to that. But it shows you under our map view as being appurtenant with this parcel of land, as you can see, as per the certificate. So outlined in green is the 0.25 acre of irrigation in the southeast, if you can see right here, the southeast of the northwest. And the house is right here where it's used for the domestic use. Okay, so conveying the water right, you would have to have this parcel of land to convey 100% of the water right. Okay, so hopefully that's clear. We're going to go on with another example just to help kind of get the meaning of appurtenance. Okay, so here is a proposed determination book. It's been decreed by the court. Another perfected document that Chris talked about. And on this proposed determination book, it lists the place of use. This is a point-to-point stock watering right. Okay, so as shown on this, it shows stock watering directly on the stream in the northeast of the northwest of Section 3, and then where the stream leaves in the northeast of the southwest of Section 3. So if you look at our maps, you can see the 2 points from here to here. That is a stock watering right. You have to show all the land within that point to point to get 100% of the water right. People misunderstand. Some people think if they just show this parcel and this parcel, they get 100% of the land. That is not correct. It's a point to point, so just remember that. Here's the professional's map that was submitted with the ROC. Here you can see his parcel that he is conveying is outlined in purple, and then you can see the point to point. He outlines that in green. So in this case, he would get 100% of the water right by appurtenance. Okay, does everybody get that? Does anybody have any questions on that? Okay.
So he's shown it all the way to the top. Oh, sorry. So he's shown it all the way to the top of that tract now?
Yes.
So does that now change if he splits that lot? Is that going to change your percentage later on?
Yes.
So you probably
It
only
would only
want to
be
show,
a portion conveyed.
Right. So you probably only want to show that point to point only, correct? On your map?
Yes.
Okay.
The point to point where your parcel is. If you only have a portion of that, that's all you're going to show. And then you're going to have to tell us what portion you're claiming of that water right. Does that make sense? Okay. So, okay, now that we have talked about appurtenance, okay. Now that we've just talked about appurtenance and how water is appurtenant to the land, here are some exceptions to that rule. So now that I've got you knowing what appurtenance is, here's the exceptions to that. Okay, a water right appurtenant to land shall pass to the grantee of the land unless the grantor specifically reserves the water right or any part of the water right in the land conveyance document. So if you're reserving, make sure you reserve. A lot of people think if they don't list the water right number, that it's reserved. That is not true. You have to specifically reserve and use that reservation language. Okay, conveys a part of the water right in the land conveyance document. So if you just convey say it's a 4 acre feet water right, and you only convey 1 acre foot of water, and you list the water right number, the rest of the water right is reserved of that water right number. Okay, so conveys a separate conveyance document prior to or contemporaneously with the execution of the land conveyance document. So if your deed is, and you've got a water right deed, is recorded prior to the land deed, then the water and the deed is severed. They're separated now. Let's see, the water will not go with the land deed if it is recorded prior to or at the same time. Now, a lot of people like to, because they don't want to warrant the water, they'll do 2 deeds at the same time. They'll do a land deed and then do the water deed, but they're the same owner. So it still is conveying the water and the land. Okay, so in such events that the land or the water is used may transfer to a new name, but the water right ownership will remain unchanged. So you can sever the water from the land. And I think people have a hard time understanding that, that you can sever both of them, because people say, no, it went with it. No, sorry, it was sold off before. So with those exceptions. John?
Out of curiosity, the number 2 bullet up there where you say if a deed contains a specific. Okay, I'll start over. But on your second bullet up there where you have that it conveys a part of the water right, the land conveyance deed, if you have no reservation within the deed and you have other water rights that are appurtenant to that property, are they conveyed with that deed as an appurtenance?
They can convey by appurtenance with the other water rights. It's just if you listed one water right and part of that water right. But if you don't list the supplemental numbers, they can go by appurtenance.
Okay, thank you.
Okay. Okay, so in relation to water right conveyance by appurtenance, on 73-111, it reads in our statute, if a county recorder records a document that conveys a water right appurtenant to land and relies on the document to maintain a track index, the state engineer shall rely on the document as an effective conveyance of a water right appurtenant to land. Now, this statute was implemented in 2011, and what this means is if there could be a document that the county recorder accepts and updates their records with, if this is the case, we will also rely on this document and update our records. However, as per Rule 655-3-4.5, the requirements to use this statute for any of the professionals are you have to show unity of title. So you will need to show unity with the owner on the water right record as to the landowner on the document. They have to have unity of title. You have to have a copy of the track index or abstract. There's different names for it. But this shows a true chain of title to each tract or parcel of land from the county recorder's office. It's a summary of the transactions. And or an affidavit endorsed by the professional affirming that the water right has not been severed from the land but remains appurtenant to the water right. Okay, so these are the rules to use that statute. Jared?
Can you give us examples of what documents? Are these affidavits of heirship or?
Well, some of them, I've had one where there was a deed and it did not show them. Oh, sorry. Maybe we should. Did everybody hear his question? He wants examples of how this what documents are used. I've seen documents of heirship, but I've also seen deeds where we don't have them as joint tenants, or it's prior to 1997 when it used to say husband and wife on the deed and it was considered tenants in common, but the county recorder accepted the affidavit severing the joint tenancy and changed the name, even though before 1997 it wasn't considered that they were joint tenants. I've had people prove that Yeah, the county recorder accepted it, so you guys have to accept it. Also, airship documents sometimes is accepted. So it just depends on the document. There are, I don't know, deeds can be, conveyed and the name could be a little bit different, but then it's accepted the next deed. So things like that. Does that give you some examples? Okay. Okay. So this is one of our biggest confusion when updating water right ownership, is this date, May 4th, 1998. So why is this date important? I want you, no matter what, if anything, remember this date, okay? May 4th, 1998, especially if you do reported conveyances. On this date, the statute changed to provide that not only perfected water rights can be conveyed by appurtenance, but also approved water rights can be conveyed by appurtenance. Okay, so remember Chris talked about the perfected and unperfected. So this date is pretty confusing for professionals that are doing a chain of title prior to the May 4th, 1998 date. The first deed is recorded prior to this date, and the water right has never been perfected. It's just for land only. The deed is just conveying the land. And unbeknown to them, it would not convey by appurtenance because only perfected documents can be conveyed by appurtenance prior to this date. So that's why you need to remember this date. So before May 4th, 1998, if you have a deed, you should always question, only perfected water rights can be conveyed by appurtenance. Okay? After May 4th, 1998, not only all perfected documents can be conveyed by appurtenance, but also all approved documents can be conveyed by appurtenance. Okay, so we're going to go ahead and take a break. And I want you to wrap your head around this May 4th, 1998 date, because when we come back, we're going to do some problem solving associated with this date. Go to the bathroom, wake up. I am just going to reiterate this date, May 4th, 1998, because the problems that I'm going to do are associated with this date. Thanks. Okay, so remember before May 4th, 1998, only perfected water rights can be conveyed by appurtenance. So if your deed is dated prior to this date, you need to question it, okay? You need to review our water rights. Give us a call if you want, but you need to make sure anything dated prior to that is only perfected water rights that can be conveyed. Okay, after the May 4th, 1998 date, not only all perfected, but approved water rights can also be conveyed by appurtenance. Okay, so is that clear as mud? Let's go ahead, and we're going to have an example. Your first deed is recorded April 28th, 1976 for land only. No water rights were mentioned on the deed. Then you look on our water right database, and you see there's a certificate that was issued March 15th, 1970, which is a perfected water right. So does this deed convey by appurtenance? Now I'll let you think about that before you answer, and we'll make a little visual, okay? So here is your deed. Okay, it was recorded April, let's see, I need to be on this side. April 28th, 1976. Okay, there's no water rights, just land only. Okay, and you've got your deed, everything matches up. And then you look at water right. And on the water right, as you go to scan documents, you see the certificate issue, March 15th, 1970. Do I have what? I know, okay. Well, yeah, I've got lots of different colors. We'll try purple. Okay, so this is the certificate. So would this deed, could you convey it by appurtenance? I hear a lot of nodding. Why? Yes, because it's perfected, right? Okay, It was perfected prior to the date of the deed, where only perfected water rights can be conveyed by appurtenance prior to the 1998. Okay. Okay, so what if the certificate was March 15th? I should have left that up. What if the certificate was March 15th? 1985. Can you still see that? Does it convey the water right by appurtenant if the certificate was 1985? Why? It's not perfected. The deed was 1976, if you remember right. And the water right certificate was 1985. So that would not convey by appurtenance. These are the things you need to remember. You need to look at the dates. Okay, so let's try another example. Okay, so the water right was certificated on March 15, 1970 to be used on Lot 10. Okay. A change application was approved, and Chris talked about change applications, right? So everybody knows what a change application is. Was approved on April 10, 1996, changing the place of use to Lot 5. The change application was certificated on May 20th, 2005. Then you look at your deed, and your deed is recorded May 4th, 1996 for Lot 10. So, does this convey by appurtenance? I'm going to draw a visual. It's easier for me. I always have to draw visuals. So, okay. Here we go. We've got the certificate on Lot 10 was issued March 15, 1970. Okay? And this is for Lot 10. That's the place of use that was listed on the certificate. Okay? Then you've got a change application, which usually starts with a small a, and you've got that approved for April 10th, 1996, and these people changed the place of use to Lot 5. So this is the place of use for the change. Okay? So then you look at your deed. Well, and this person comes in and they say, I have Lot 10, and I have a water right on Lot 10, and his deed is recorded May 4th, May 4th, 1996. So I'm going to put up here. No, I do not have good handwriting. I'm left-handed. So, okay, so you've got, can everybody see this? So here you've got your certificate. Let's do this. Here you've got a change application, and also, I guess you should put the change application was certificated May 20th, 2005. Okay, so does this deed, does that convey it by appurtenance? Lot 10. Okay, why? You're right.
Because it's still it's appurtenant up to that date until it's another perfected right by that 2005 date.
That's right, because your deed was recorded prior to the May 4th, 1998 date, and prior to being perfected on the change, then this deed would go with Lot 10. Now the sad thing is we have these people that did the change application thought that when it was approved, they thought, well, we can now go ahead and deed that other lot because it's now appurtenant to this. That's why they're doing a change application to change the place of use to Lot 5. But the thing about it is they did not reserve it on the deed. That was their problem. They didn't reserve that water right for that lot, so it went by appurtenance. So you've got to remember dates, okay? Dates are very important on those kind of things. They don't have a water right. They've conveyed it with their deed. Yeah, because some people they don't bring the deed in right away, which you should. She's asking what would happen with the people on Lot 5. They should have brought in that deed right away, so before it was certificated, then at least the poor Lot 5 people would have to go buy some water.
So what happens with the certificate from 2005? It's just not.
It goes
negated?
into the other people's name that has Lot 10. They'll have to do another change application more than likely to change it back to Lot 10. I know. Jared?
Well, then obviously lot 10 probably didn't use the water.
Well, I think that Lot 10, they were using the water, thinking that they changed it to Lot 10, so they're both probably using the water as a problem. So we've got an over appropriation. So this is why, title and water rights can be complicated. We're dealing with this all the time, these kind of situations. So let's do that. Your deed was recorded October 5th, 2000 for Lot 10. So this is changed. It's now October, what did I say, 5th, 2000. So if they deeded it then what would happen? Would it be appurtenant? Remember this date, May 4th, 1998. Now you've got your Lot 10 up here, and they deeded it after the May 4th, 1998. The land was severed from Lot 10 and now is used on Lot 5. Okay? Because it was certificated and it was after May 4th, 1998. And it was approved, and all approval after May 4th, 1998 can be conveyed by appurtenance. So these are things that you need to be looking for when you're doing searches, on the division. We would rather have you call us than turn in something that says all we're going to do is turn it back. So dates are very important. Just remember that. So now I'm going to kind of throw you a little curveball. A lot of times the professionals, you guys, are dealing with defaults or foreclosures. So, for example, Farmer Jones a deed of trust for Lot 10 on February 5th, 1980. Okay? His land goes into default, and a trustee's deed is recorded on May 10th, 2001. The water right was certificated on March 15th, 1970 to be used on Lot 10. However, they did a change application which was approved April 10th, 1999, changing the place of use to Lot 5. So, does the trustee's deed convey the water right? Let's just do that. I hear yes. Why? Okay, I'll tell you, that's not why. Okay, so we've got to always remember the deed of trust, okay? The deed of trust is the contract, okay? The deed of trust was recorded February 5th, 1980, right? Deed of, okay? Then, for Lot 10, yeah, sorry about that. Okay, yeah, Lot 10. Okay, so remember that. Now, the trustee's deed, which comes out later because they foreclosed and they lost their land and then the bank sold it. That's where the trustee's deed comes in play, right? So that was recorded May 10th, 2001. Okay, we'll just put trustees. Okay, then the water right was certificated. I know there's a lot of documents, a lot of dates. That's all we talk about. Dates are so important. March 15th, 1970, to be used on Lot 10. Okay? And then the change application, again, for Lot 5 was approved April, what did I put there, 10th, 1999. Okay, so we have to keep in mind this encumbered the water right, okay? So you've got the deed of trust that encumbered the water right. The trustee's deed, the date of that, I mean, it doesn't really matter in this instance if they have a deed of trust. It's this date. And that date was prior to this being approved, and it was in between when this was certificated. It was encumbered under Lot 10. Okay, does that, so always remember, this is what you've got to remember is the deed of trust. We actually ask you to submit the deed of trust when you are submitting a trustee's deed, and that is because sometimes on the deed of trust we've seen where they've reserved the water right. And so if they've reserved the water right, it definitely does not go with it. So
there's no involvement with the mortgage company with the change application?
no, no. More than likely, the people just think they own the water right, and maybe they think they're not going to default. They keep making their payments. So then they think, I'm going to go ahead and change it to Lot 5. It's really sad, but this happens a lot. Okay, does that answer your question?
Well, the Division of Water Rights doesn't ask for mortgage or trust
Deed of trust, and we don't. We expect someone to do a full title search to try to find that deed of trust, and that's where you guys come in play, where you need to do a full title search to find those. Okay.
What if the lender has that water right on that trust deed?
Then they get it.
Okay.
In fact, we've had some times where people will sell the water right in between these two dates. We update our records because those are the documents they give to us. And then all of a sudden the bank comes back and says, we're taking it back. And the people that they sold it to, I always say to people, please do a title search. Find these deed of trust. It could be encumbered. So we are constantly telling people, please make sure you do a title search, because we have had to take water back and people blame us, you know, and we get yelled at, Sue and I. So, you know, it enough. Do a complete title search on those. It really does help.
So was the answer to the question yes or no?
The answer to the question was yes. The deed of trust, the contract was recorded prior to that change application being approved. Does that answer your question, John? Okay, so these are some of the problems we're dealing with on a daily basis. So hopefully when you get deeds older than the May 4th, 1998 dates, you will be a little bit more aware of the conveyance. Okay, you can give us a call, we can help you out, but we really wanted you to be aware of this date because it really does issue a lot of problems for the most part. Okay, I'll just go ahead and erase this. Okay. We'll turn the time over to Sue to do our mapping standards. Okay.
Going back to your first example where it did not convey for when the deed was 1976 and the certificate was 1985 because it wasn't perfected.
Yeah.
How do you get around that to convey it?
You have to do it by water right, or you have to do quiet title. I mean, there's a lot of different scenarios, and we have to look at every water right differently. So that's why it becomes so complicated. So when you do have an issue like that, give us a call. We can try to give you some pointers on what to do But I say, when in doubt, you know, if you really want the water right and you want to have it not encumbered or anything else, I would quiet title it. Does that answer your question?
So now that Dana has talked about appurtenance, the Division of Water Rights requires that if you're going to be updating your ownership by appurtenance, then you are to submit maps. So if the deed does not specifically identify the water right, then maps are required to establish that appurtenance of that water right. They're important because they identify the parcel that's described in the deed in relation to the place of use of that water right. So you have your parcel and you have your place of use. They have to come together. That is the appurtenance of a water right. What the map does is it depicts the place of use of the water right overlain by the metes and bounds description in the deed. So what we tell people is when you submit your documents to the division, your report that you submit tells the story because you have all of your deeds. But most of us are visual creatures, so we like to have illustrations to that story. That's what the maps provide. They provide us with an illustration to that story. When we're thumbing through that file and we're looking at those deeds, no one's going to take time out to read those metes and bounds descriptions. But then we go right to the map and we go, oh, I see where that parcel is. Makes total sense. And then we can also see possibly how the place of use of that water right, it may have started out with 100 acres and now it's being broken down into several parcels. We see how that 100 acres is being broken down through those chains of title. That's why our maps are important. That's why we're so strict about our maps. Dana and I are extremely strict. So we just ask that with these mapping standards that we have provided you, if you are going to be updating by the conveyance or of a water right and by the appurtenance, that you refer back to those mapping standards. They're a big help, just identifying what we require. And that way then you won't have your rock sent back to you asking for better maps. So, again, why is a map important? The map is important because it does easily determine that the water right is appurtenant to that property described in the deed. And that's what we're having to do, is show the appurtenance of that water right in relation to that land. So again, we tell people, if you're in doubt as to when to submit maps, all you have to do is look at your deed. Does the deed specifically recite the water right? If not, then you're going to need a map. Simple as that. So let's go over our mapping standards, and hopefully each of you have a copy if you want to follow through with those. Our mapping standards are also found under our rules 655-3-5 if you want to follow along with those as well. The first thing that we ask is please make your maps legible. Make them so that they're readable for us. You know, we're not getting any younger and our eyes aren't getting any better, so it helps to have legible maps. And I know that sounds silly, but you'd be surprised how many maps we do get that literally are not legible. And on your map, you will need to identify your section, township, and range. You need to identify a section corner. Identify that water right. Sometimes maps can become loose from the rest of the documents. They could get lost, and then we'll end up sending them back, and then you guys call us up and you're mad at us because you did send in a map and then we don't have it. We lost it, our error, but it's helpful to have the water right number on that map. We also require that you have a north arrow and, of course, a scale. And then you need to depict that parcel that's described in your deed. So like if you have ArcGIS or if you have a deed plotter, something that plots out that property in your deed. Now, when you're submitting your maps, I know this might sound unkind, but please do not just print off a map off of our map viewer and put X marks the spot and send it in. We know where the spot is for X. We already know that. In fact, that's how you got it. So what you're having to do, though, is describe that property that's in your deed. That's what you're needing to show us. So what we're looking for, if you want to use our map viewer map, that's great. But on that map, you will need to depict your parcel. So we ask that you highlight that parcel. And then we also ask that you include the acreage of that parcel. And the reason why we ask for the acreage is because if that water right requires that, for instance, you need a half an acre of irrigation to water, then your parcel needs to be large enough for that half acre of irrigation. So we have to look to see the amount of acreage in comparison to what's required on the water right. And then you need to identify the place of use. So here we've hatched or shaded the place of use. This water right in particular was for 1/4 acre of irrigation. So he has hatched where that 1/4 acre of irrigation is, and as you can see, it's within the boundaries of his parcel. Then you also need to identify the lesson acceptings on your map. So if the lesson accepting is for a road, or it might be another parcel that went someplace else, you need to identify that, shade it in a different color. We also ask if you could possibly have legends. The legends, for instance, on this particular map, what the professional did was he provided us a legend of that parcel, the color. He also identified that same color and highlighted that in his deed. And we would ask that you do highlight that parcel in your deed. Many times we receive deeds that have multiple parcels. And as much as we would like to know which parcel you're trying to claim the appurtenance, we don't. So if you would highlight that parcel for us, stating this is the one we claim the appurtenance to, and with the same highlight, possibly highlight it in the same color on your map. And then we can cross-reference and see which parcel you're referring to from deed with map. And then, of course, like I said, your legends. You could even highlight your parcel and then list this is parcel number 1 and refer back to the deed that it's supposed to be associated with. Now, the one thing that some people ask is, can I use a county parcel map? And yes, of course, you can use a county parcel map. In this situation, what this professional did was he provided us with a county parcel map of that whole section. And then he did outline, as you can see here, that small little parcel. But with just this one map, he hasn't completely met all of our mapping standards. He's identified a section, corners, so on and so forth. But along with this map, he has also given us an enhanced version of that parcel. So, and you're welcome to do that as well. And he has now told us, oh, this parcel is 2.37 acres. He's showing us where the well location is. Let me just emphasize, a lot of times people are confused with the point of diversion and the place of use. What you are having to show us is the place of use. Many times we get maps that depict the point of diversion. And the point of diversion, again, could be in a different section, could be in a different 40-acre tract than where that place of use is. So then we end up having to send everything back again, saying you haven't supplied us with the right maps. So we just ask, make sure that you have given us the map for the place of use. Now, each deed is to have a map. each deed you submit is to have a map unless that property remains identical all through the chain of title. Now, again, all maps that you submit, they're solely the responsibility of the professional submitting them. And of course, you know, if the division sends it back, we may request additional information to, that we need to support your map, or more information on the map that can help us easily identify either 100% of the water right that you might be conveying or a portion. Sometimes when you start submitting portions to us, because a large parcel of land is now getting broke down into parcels, it can become a lot more complicated as to possibly what you may be able to claim or cannot claim as far as for the portion of that water right. Now, if you are going to update by the appurtenance, the law does require that only a professional licensed in Utah can submit the reports. However, those professionals would have to be an attorney, a professional engineer, a title insurance producer, or a professional land surveyor. So again, if you're having to update the ownership by the appurtenance, only one of these 4 professionals can submit the paperwork to us. Turn the time over to Dana.
Okay, so we've talked a lot about the report of conveyance. We've talked about how addendums and assignments could be used as a report of conveyance when the county recorder submits them. Well, here is the report of conveyance. This is a 100% form, and the report of conveyance consists of a form provided by the state engineer that must be completed by the submitter. Okay, we do not monitor, Sue has talked about, we do not monitor any transfers of water rights. We rely on you, the water user, to file a report of water right conveyance. Okay, this form notifies the division of when the ownership transfers. Thus, the purpose of an ROC is to notify the division of the true ownership of a water right. Okay, so this is the main form. This is 100%. Here is a close-up of that form. We have changed a few things on the form for you that use it all the time. The first thing that we added to help people, because a lot of the time we get stuff that does not have maps when they're conveying by appurtenance. So if no water right number is mentioned on the deed, is a map submitted? This helps and reminds you that you need to submit a map with this deed. Okay? We've also added email address. Now, some of the professionals sometimes put their email address here. You've got to remember, this is for the grantee, the new owner. If they want an email of the notification of the update, they won't, if you put your email address there as the professional, you'll be getting an email and they won't even know of the update because we don't mail it to them once we have an email address. So this is only for the grantee if they want to be notified of the update, okay? So other information that needs to be submitted with the ROC is sufficient documentation presented as copies of properly recorded documents to demonstrate the chain of title connecting the owner on the division of rights records to the new owner claiming ownership of the water right. Okay, so the report of conveyance needs to include all the information, all the documents. Also, of course, again, we just talked about maps. Remember to submit your maps when conveying by appurtenance. Any additional information like affidavits, opinions, or explanation is always welcome to us. We kind of like that. It helps us not overthink it otherwise. So if those are deemed necessary, and also a fee to the state engineer. It costs $40 for a filing fee to submit a report of water right conveyance. So we'll just go over this. Here is a report of conveyance that's completed. It has the owner of record as the grantor. So you always start with the owner on the division of records. You start with that owner. And then as according to the deed, it's got the grantees on there. And it's, of course, according to the deed. You notice they have the date signed, date recorded. They also, by appurtenance, yes, maps are submitted. So all that is complete on that. Now, the remainder of the report, because it has two chains, some people say, do I have to submit a report of conveyance with each chain of title? No, you do not. You just have to show us how it goes. And again, you start with the owner on our record. Okay, and this is the second chain. He starts with the grantee on the top part right here. He starts with the grantee as the grantor now. And then he, as the grantee, this is the owner, the new owner. And he puts the address. Remember the mailing address. A lot of the time we've had to send it back because they don't have a mailing address, which is really a stupid thing to send back. But we do that. So make sure there's a mailing address. Also, if you note, he has given us information on the conveyance right here. He has, so we don't leave anything to the imagination. He's told us a few things that need to be looked at with the water rights. Now, the problem with reported conveyances is, I know you guys get frustrated because we do send a lot back. I tell people every 3 that I review, I probably send 1 back. Why is that? And it's because I think you just assume we're going to know something we don't know. Okay, because a lot of the times it's a misunderstanding. I sent one back the other day because their map was off. And I was kind of like, where is the place of use associated with this? And their map was just not giving me enough information. I sent it back and they called me and explained, and I'm like, okay, well, why don't you explain that? You know, give me an explanatory, change your map to depict what you're telling me, and then send it back in. That's all that was needed, was that explanatory and the change on the map. That's why we have mapping standards. So we will know where that is within Utah. Okay, so sometimes we'll get a square on a paper. That drives me crazy. We don't know where that's at. So just that there's no misunderstanding. Help us to understand. Don't wait until we send it back, because if it's important to you and you want it updated, don't leave anything to the imagination, because me and Sue have worked in water right title for a long time and we have a great imagination. We've had a lot of situations. So when in doubt, we send the report of conveyance back. That's why you receive them back. Okay, and then when they come in, just so you know, it goes on the bottom of the pile. If you've seen our pending list, it's at 230 now. It'll go on the bottom of that pile. And, you know, if your clients are getting upset because we're not updating, you know, I'm sorry, but we've got all these people that have paid and we have got to do their report of conveyance. So when you can always call, you can always meet with us. We're happy to do that when you're in doubt and submitting a report of conveyance. Okay? So just as a note, only 1 report of conveyance per water right. Okay? Also, if you have 2 owners that need to be updated, you will need to file a separate report of conveyance. Okay? You just can't put that other owner in the chain and expect us to think we're going to update the other owner and the last owner to do that. So you need to submit 2 report of conveyance. Also used if there are several owners on the water right and you are giving 100% of that one owner's interest, of an owner's interest. Okay? Here is our portion conveyance form. And this is, of course, used when a portion is conveyed. Now, it additionally requires, you see, it's a little bit different, and that's because we want you to put from the water right what is being deeded, okay? And we do have a problem with, there's several chains of title, and you don't put anything on this, and then the end, it has it. We want to know what's being deeded throughout. Like if you've got your first deed, and it's conveying 100% of the water right, and then you go to your second deed, and it is only conveying 40% of the water right, we need to know. We need to know what is that in beneficial uses. I mean, if you have to do it in percentages, That's okay too, but we need to know throughout the chain of title how that is going about, okay? Also, if there is a change application on the water right, we need to know the uses, and it says a pending change. Just remember, a pending change. That's one that's just been approved and hasn't been perfected yet. Okay, we need to know what you're taking from the change. So these things are important, okay? We need the amount and the uses on each chain of title. Okay, so here is the second page to both forms. This is the signature page. And the signature page has changed also. We've changed our rules, and I think the professionals like that. We were talking about that, and we were saying how since the rule changed, we have not had one owner sign it. We've just had the professional sign, because that's all that needs to sign it now. And I'm thinking, so that probably is easy on you professionals, not to have the owner sign that. We see that now, just the professional signing it, which, as per our rules, that's what you can do. So if an owner updated without the professional, they are attesting that the information contained in the ROC is true and accurate. Okay? They will need their name and a signature. Okay? If it is signed by the professional, I'm going to, because this is what you're going to be stating when you sign this, is the professional was retained by an owner of the water right to prepare or supervise the preparation of the report of conveyance. That the report is true and accurate to the best of the preparer's knowledge, that an appropriate search of county recorder records has been made, and that the attached documents evidence the ownership interest of the grantee. So you're doing your due diligence. And that's what you should be doing anyway for your clients. Okay, and we will require the professional name, the profession, and just a side note, an escrow officer does not do a report of conveyance. Okay, the title agent has to sign off. It can't be the escrow officer. And don't ask me why, because I don't know, but that's what has to be done. Okay, and you need your license number, you need the signature, the professional signature, and a phone number and an address, and that is because for us to send it back or for us to call you. If it's something little, we'll call. If it's something that it's got to be a lot of work done, we'll send it back. And honestly, more than likely, we'll send it back because we're kind of just, I don't want to say this, sounds terrible, but we just get tired of people not caring how they send in the report of conveyance. And I think, you know, in your world, you're probably sick of us sending it back, I'm sure. So I totally understand that, and I'm sorry, but, you know, we do need that information so we can do that. Okay, so for a helpful guide in determining if your report of conveyance will meet the division standards for processing, and this processing, just so you know, the report of conveyance, when it first comes in, is looked at by our receptionist desk, okay? And they look through a checklist. This is the checklist. And if it doesn't have all that stuff on the checklist, they send it back with the fee, okay? They don't. So you'll want to make sure that at least through them to get to us, because then we're the next one that reviews them. So you want to make sure it starts with the owner of record. You're in chronological order. The report of conveyance is signed by the water user and or professional. Does the ROC have a mailing address of the new owner? Does it have maps if it's conveying by? Are all the other documents, the deeds, they submitted? And have you submitted the fee? So this is good to note, and this is on our website for you to note on there. Okay, so now we've talked about when professionals can update. So when is an owner authorized to update without the professional? This is rules, and it's 65. Sorry, my mic I can feel is going in and out. So, but I tell Carmen I have a very loud voice, so you probably can hear me anyway. Okay, so when a water right is authorized to update, an owner is authorized to update on the Division of Water Rights records, is without the certification if, as per 655-3-7, when or the deeds convey 100% water right. The water right has to be specifically mentioned, the water right number. Some people think that if they just say water right, that's specifically mentioning the water right. That is not. You have to mention the 2-digit, 4-digit number that Chris talked about earlier. Okay? On a portion of the right, if the owner is updating, all owners of that interest have to sign the deed. Okay? Clearly identified. Again, the water right number. And the sole supply has been established. Chris also talked about sole supply. So all that has to be done in order for an owner to convey. Okay, if there are multiple chains, it has to identify the water right number, and it has to have a complete chain of title. All the deeds in that chain have to mention the water right number. Okay, is there any questions on, am I going too fast? Is everybody falling asleep? Okay, good. Okay, so other instances when an ownership can change the Division of Water Rights records. Okay, name changes. So as per our rule 655-3-4, let's just say of the water, she gets married and becomes Jane Smith. To update ownership on her records from Jane Doe to Jane Smith, she would have to supply a copy of the marriage certificate along with the report of conveyance. Let's say Jane Smith gets a divorce. I know, real quick marriage. And she was granted a copy of the divorce decree, granting the name change, and then she would that with. Just be aware that the divorce decree or conveyance documents still may need to be submitted. Okay. Okay, joint tenancy. Here's another date, and all you title people out there probably know this date. Oh, sorry. Go ahead.
Do you need the whole decree or just like the first page
no,
and the
just the
last
first page and probably the page that changes the name.
Okay.
And maybe even the last. Yeah. Yeah, I always tell people, even with trust, don't give me the whole trust. But you do know where it says that, so we note that. Okay, so joint tenancy. Here's another May 4th date. This is all the legislature, they've approved all this stuff, so May 4th seems to be the date. 1997, prior to that, if it was listed on the deed as husband and wife, then it would be considered tenants in common. I think that is backwards because that was pioneers. You should be joint tenants. But, prior to that date, it was considered tenants in common. Now, after the May 4th, 1997 date, if it did list husband and wife, it now was considered joint tenants. Joint tenants. So just a reminder of that, okay? But in case there is a joint tenancy, the person would just have to submit a copy of the death certificate or an affidavit certificate, and then the joint tenancy can be severed, okay? Just another note, on our files, sometimes we don't have them as joint tenants on our water right files. We didn't put it or whatever, or they came in, filed the water right, and didn't put joint tenants because they didn't think about it. You will have to submit the deed previous showing us that they were joint tenants, okay, on the land. So remember that if it doesn't state it on our file, you might have to submit the deed prior to that showing that they were joint tenants. Okay, so now we'll just turn, corporations, I'm forgetting, sorry. Okay, so a corporation, if a corporation, we will require the name change to be stamped in the Department of Commerce, or in the state that it was incorporated in, okay, that the corporation was incorporated in. You will need to file those papers and show that it was stamped with any one of those departments, okay? State of Utah, Department of Commerce, or the state that it was incorporated in. Okay, now we'll turn the time over to Sue for the remainder. Did you turn on your mic?
Did not turn on that mic. So now we'll talk about processing the ROC. Once you have done all of your paperwork and you filled out your form, you paid your fee, and you submitted it to the state engineer, this is where Dana and I step in, and we have to start reviewing all of those wonderful rocks that come into us. Like she said, right now we're sitting at around 230, 250. That creates a lot of stress for us because we're not used to having that big of a number. There must be something that's just exploded in the market lately. Either that or we're just getting old and slowing down, but our eyes again can't see. But let us just walk you through what happens when your ROC has been submitted to us. The state engineer will assess whether or not that rock is complete in both its form and its substance. So has it basically started with the owner of record? Is it by appurtenance? Did they submit their map? Are all deeds in the chain of title that's listed on the rock? Did they meet the mapping standards? So on and so forth. That's basically what the initial review is going to be. Now, if ownership, if we find that the rock is complete, then your ownership will be updated and we will send a notification to the new owner. It's a letter that comes out to confirm that, yes, you know, welcome, this is hurrah, we were able to update your ownership. And if we have found that it's not complete, then the rock will be returned to the party that did submit the rock with an explanation as to why it was not complete. And we would ask that if you're going to resubmit the rock after it's been sent back to you and you've corrected what you need to do, or we've asked for additional information and you resubmit that rock, we ask that you resubmit the rock along with all of the documents that were sent back to you. We want everything sent back. Because sometimes we'll send back the rock and everything, and then what they do is they just send in the deed that was missing with no rock, and then we don't know what to do with that deed. And then they call us up and said, didn't you get this? And then one thing leads to another. So if it's sent back to you, please resubmit everything back. And also we want to point out that in resubmitting it back to us, it goes back to the bottom of the pile. So it could take some time before we are able to review it again, just to let you know that. Now, if the fee was processed prior to the rock being returned, then what we will also do is place a copy of your rock with all of the documents that were submitted with it. We will scan those and place a copy of it on our file. And as stated under the rules, that when it is returned to you, then the submitting party will also be allowed an additional 90 days to complete any corrections or any information that we're requesting in addition without having to pay another fee. So when it's sent back, you get 90 days. And we give you usually a time frame in that letter when we send it back. Please don't assume, though, that in sending it back and we review it again, that you're going to get another 90 days after that without paying another fee. It doesn't work that way. No, you get the first 90 days. Okay. Also, we want to point out that the title team, Dana and I, we do not accept documents via email. That means we don't accept them to be received, to be processed in order to update your ownership, nor do we receive documents to review for you prior to you submitting documents. And if you feel uncomfortable before submitting something, again, like Dana said, please feel free to call us. We'll take the time to discuss something on the phone with you. If we feel it necessary, we may want to set up an appointment and go over the documents that you have. We're not mind readers, and we also can't see through telephones. We're not telepathic that way. So a lot of times it's helpful to be able to see the documents. We can't just assume what you have in front of you is going to work. So again, you know, if you're in doubt, just call us or call and make an appointment, and we'll be happy to meet with you and sit down and go through whatever you have. Also, if a rock is received in the mail or it's hand delivered, like Dennis said, it does go through an initial review. When it hits our front desk, they go through with the checklist, and if anything is missing based on that checklist, they will first send it back with a letter to you. So sometimes it doesn't even get to Dana and I to review yet. And the last item on our list are conflicts. So there can be times when a report of water right conveyance is submitted that may conflict with another report of water right conveyance. So when this occurs, we have established rules as to what we should do on our part. And it's found under R655-3-6. What the state engineer will do is he will not process the report, and it will be returned to the processor. However, its receipt will be noted on our records, and the disputing parties will be notified. The state engineer will take no further action on that water right until that conflict is resolved. We will also flag the database on the conflicted holders on that water right. So rather than try to appeal to the state engineer to resolve that matter, the conflicted holders will need to resolve the conflict themselves. And they can either resolve it by an agreement or by court order. But whichever way they choose to do it, the documents will need to resolve the title question. It must directly address that title conflict, and then it will need to be updated. It will need to be recorded with the county recorder. Does anybody have any questions on conflicts? There is one exception, and that is if we receive a deed that does take precedence over another deed that's already in our file, we do not consider that a conflict. We will update ownership. Now, if we have to take water back, that party might feel there's a conflict, but again, the dates on those deeds usually take precedence over anything else. Okay. I think we'll turn the time over now to, oh, did you have a question? Jared, did you have a question?
Yeah, I was just wondering, do you notify the people that lost the water? So if you see a conflicting deed and you send out notice to the people that lost the water right, correct?
Yes.
Okay.
The only time we do not do that generally is if there's been a deed of trust.
Okay.
And those people usually know they've lost it if they've gone into foreclosure on that. Oh, there is a couple of final notes though. We just want you to know that we do not assure that there may be other title documents that do exist out there that may conflict with ownership. So updating on ownership on the records of the state engineer does not warrant or guarantee title to that water right. So if you wish to update, again, it is only emphasized that you make a complete and thorough search of the county recorder's records. And also, we always do this as a side note, The filing and processing of a rock is neither an adjudication of a water right, nor is it an opinion to the title of that water right, or does it determine the validity of that water right. Those are all separate. Okay? Thank you, you guys. And hopefully we'll get to work with a lot of you in the future.
Sue, I think we had one question back here.
Oh, okay.
Just
Dang.
question,
Ed Bowler.
because I'm confused now. On a trustee's deed,
Oh, this is for Dana.
She acts like she never deals with me.
Dan, on a trustee's deed,
She would do the same to me.
let's say the water is not listed on that trust deed, okay? However, it's not reserved. However, it's pertinent to the ground. So when that trustee's deed comes in, does the pertinence doctrine apply?
Yes. It still applies. If that deed of trust has the ground that it's pertinent to, it's encumbered under that deed of trust. So the trustee deed comes in. Is that what you're asking?
Yeah.
It does.
So the pertinence doctrine does apply then?
Yeah.
Wow.
Yeah. That's why you gotta look at the deed of trust.
But, okay, that's interesting because, well, because here's the question. See, even though that's a pertinent, if they deeded that water off prior to that trustee's deed, that water's gone. So the pertinent doctrine wouldn't apply.
That's right.
Okay.
So that's why there's exceptions, and you've got to make sure you know what's going on. That's why you do a title search. If the water was sold out before that deed of trust, it was gone. It was separate from the land. People do that. People do that.
I've seen it. Yep.
Dana, I've got a question. You tilted me once on your report of conveyance. If Ed and Brett and I all own a water right, and I'm deeding 100% of my water right, 100% of my ownership, I can use 100% form?
Yes.
Okay.
Okay. All right. My name is Jim Reese. I'm in our technical services section, which includes maintaining our website. And so I've been tasked with showing you some of the things you can see and do on our website. So the address is waterrights.utah.gov. First thing, so we talked about some of the statutes today, and under law and agreements, we have a link here to water rights statutes. Okay, and we also have a link to the administrative rules. So, a lot of the stuff you do with title is guided by these rules. But if we go to this link, the water rights statutes, we have links to the different statutes by topic, or you can go straight to the, well, all of these links will take you to the legislature's website, but we can scroll down to the bottom, and we have a section there for title and link to those statutes that have been referenced today. Let's see. Also, we have a link right here, applications and forms. These are all the different forms that can be filed in our office. Under this ownership application section are the forms that deal with title. So we have the report of conveyance and for 100% or a portion. We have the assignment form, and also forms for land deed addendums and water deed addendum. Okay. Go back to our home page. Then also just under this link programs, we have these are different programs that our division deals with, and so we have a section for title transfers. You can also find here links to the forms except for the assignment form. That one is not here, but the other forms are here. We have a list of title professionals, and if you're not on that list, you can contact us about getting on that list. We have this link, the rock process status. This is the list of all the reports of conveyance that are currently being worked on. So if you are wondering where yours is in that process, you can find it on that list and see what its status is. All right. Okay, I think that covers that part. So what I also want to show you is, so talking about a water right, we can search, do a search for a water right, and pull up the information that we have for that water right. So I've got one here. Pulls up the, this is the page that Chris was highlighting in his presentation. And this is basically a summary of what we understand this water right to be as entered, and it's entered into our database. So we have some ownership information, information about priority dates and such, the location of the water right, including the amount of water, the points of diversion, and the use. So, okay. And then also Chris had highlighted this part right here, if I can get it. Okay, so here's where you can find the type of right. In this case, it's an underground water claim. And the source of info is proposed determination. So if it's certificated, it would say that here, or if it's an application to appropriate. And so a couple things. In this case, it's a proposed determination, and there is a hydrographic survey map that was done. So if you follow this link shows all the hydrographic survey maps, the different adjudication areas in the hydrographic survey map. So in this case, we're PD book 71, map 210. So if I can come down to hydrographic survey map complements proposed determination. Right. Yeah, the map. So yeah, when we do a proposed determination, hydrographic survey maps are generated to locate and identify all the water rights in the area, and from that, the proposed determination is created. And so I can click on. Oh, that's not a good one. On this, and then these are just. I can pull up any one of these, and there's just this image of the map. Also, for a particular water right, I'm going to show you another way to see that same map. So for any water right, we can click on this link, Map View, and it will take you to our map viewer, and it will search for the water right in question. Okay, so I can zoom back out. So lots of tools on here that go along with this. So we have the public land survey system. So I can see, give me the township range section for this. We have parcels. I'm not sure that yes, we do. So here's a parcel number for this. Yeah, the parcels there are shown in white. And you can get the parcel number from the county if you need that. Let's see. So if we come here, I can add more layers than what we're shown. We have lots of information that can be mapped. So I want to show these two layers: hydro map boundaries, hydrographic survey maps. So first of all, we have a layer that just shows the boundaries of the different maps. Depending on the zoom level, sometimes these are a little slow, but I can put that hydrographic survey map that was referenced in the water right. I can put that right up on the screen and see where this plots with respect to that. Is that what you wanted on
Show
that?
them how that you can kind of, on the hydrographic survey map, when you have it up, how you can go lighter so you can still see the background.
Oh, I see what you,
Yeah.
yes, yeah. So right now I can, it's kind of hard because this particular map has a similar color to that background, but you can see how you can kind of,
And then you can click on your parcels and it'll show that that's in their parcel.
yeah.
Jim, we got just a quick question.
Oh, go ahead.
How do you get that print to print with the background with it?
With the background. So you can set that to how you want to look at it, and then over on Tools and Print, I can switch to this. So right now we're in normal view. I can switch to print view. And that's what's going to print. And I can also add annotations and stuff. So, you know, you can the information here can be used to generate a map that you might do for an ROC. But again, make sure that you're following all the map standards and including all the information that you need. Okay, let's see.
And you're depicting the deed, remember.
Yes, you're depicting the deed. So you have the parcel, and let me turn this off. Not sure why that parcel is not.
You're going to have to bring up your PLSS stuff.
There we go. So this will get you the information, but the parcel, that parcel boundary, that white, you want to make sure that actually, now these come from the counties, and you need to make sure that actually accurately reflects what's on the deed. They're not always one and the same. Let's see here. So also, let me see, let me get back to, we can do searches right on here. So I could search for another water right. Let me do, search for
You
this.
can also search through different things too.
Yeah, so let me zoom to this water right. And so this water right has several points of diversion throughout Salt Lake Valley, but I can then click on one of those. And then there'll be a link to view the information for that water right. Okay, so in this case, if you go back to that type of right, this one would be an application to appropriate. Okay. Now, on any of these, we can select this other information, we can go to the scanned documents. I'm going to go back to this other water right we were looking at that had the yeah. Oh.
So going back to the map.
Mm-hmm.
So I know I can do a county parcel search. However, how do I find place of use information for that parcel? Can I do a search like that from the map?
Not from the.
The place of use, usually if you're at the water right and you go to the map view, it'll show in purple.
I don't know.
Or green.
I don't know the water right. I just know the parcel.
And, okay, so you're on the parcel.
Okay, so,
Sure how to.
yeah, so if we, let's see, let me,
You need to do the search on parcels.
yeah, but I don't know a parcel number. Do you have a parcel number to search for?
But if you zoom in close enough, you'll see a parcel number.
Yeah.
So keep going.
Oh, I'm sorry. I'm looking at the wrong number. Yes. Yeah, so when you search for a parcel number, it'll find the parcel. And then when you're in close, then you could come to your layers, turn on points of diversion. Now I've got these points of diversion. That'll get you close, but that doesn't get you place of use. You're right.
But once you go to that water right, and then you do that again, map view, it should come up as a square where that place of use is. So once you have the water right where the well is located, if you go to that water right, click on map view again, it should show you.
And I do know that, but
Okay.
we have situations where owners don't know their water right numbers.
Okay.
They just know their parcels.
Yeah.
And can you show
And you
her
can
on
search on the
tools?
parcel. Can you show her on on
tools
search?
where you can do
On
those
search.
searches. On-
Yeah, on search.
Right.
Yeah.
That's what I've done.
That's-
But then I can't see place of use information for that parcel by doing this back.
Search
Well,
for water rights by place of use by 40-acre tract.
Right, yeah.
And then you can do layers, and once you get that point of diversion, you'll have to go into that
Right.
water right that they have. Does that,
It does, I was just hoping.
it's a long way around. It
No,
really
there's not an
Yeah, there's
easy
not an
way
easy
to do
fix.
that. But yeah,
Yes.
like John mentioned in the back, you can search by 40-acre. You can come here, you identify the parcel. You can then determine, okay, where am I? Let me turn off some of this stuff. Okay, I'm in Township 1 South, 1 West, Section 27. I can do a search for places of use there, and then, okay. All right. Okay, so I'm going to go back to this water I searched for originally, and we can look at scanned documents. So Chris mentioned that we have the paper documents up in our office that you can look at, but we've scanned nearly all of them, and you can go through them here. So they asked me to show, if I can find it, here we go. So I can come through and look for this proposed determination or decree, and that would be the document that shows that this is, what's the word I'm looking for? What's the word I'm looking for?
Perfected?
Perfected. That's it. The other P word. Perfected. Okay? And so this, you can, this one's sideways, but this, yeah, this, I think we were looking at 2531, so that would be this row here. So it just shows you the part of the proposed determination associated with this water right. And let me make sure. We also have, yeah, on our map, one of the tools you can, so we have some measure tools you can use to measure distances and areas. If, like on this location lookup, I can click anywhere and it will give me coordinates. It will give me the county, the water right area. So if you need to get that information. And do you want me to do email notification? You guys want to do that? Okay. All right. So The last thing is we have a email notification system set up where you can, for a particular water right, you can receive notifications. So if I go to water rights.
So if you want to receive notification with your clients, instead of putting the email address on the ROC, this is the way to do it.
So you can register for an account using your email address and your password. And so once you've done that, you can pick a water right. So I could pick water right, 1, 2, 3, 4. Click add. Now for this particular water right number, 15-1234, if any new document that's put on the file, I'll receive an email note that has taken place. So I can keep track of what's going on with the water right. So I think that's everything we had planned to cover. Are there any questions? No? All right.
Thanks, Jim. So I think that will conclude this training. Again, there are certificates back here, and if you have any questions, feel free to stick around and ask them. Otherwise, have a great Wednesday. And I'll be uploading those CE credits through the Utah Insurance Department for you guys, so it should get that done by the end of the week, and they should post. So if you have any questions, let us know. So thanks for attending and having interest in water rights.